everyone. Welcome. We can go ahead and start with a couple of our introductions. So we're going to be doing this webinar today. Our topic is going to be thinking outside of the state. So why our Midwest surrogates make great matches. And our guest speaker today is going to be Tim Schlesinger. He is an attorney and he's going to be helping us answering a couple of questions and things like that. So thank you everyone for joining us. Thank you, Tim, for joining us and helping us just kind of break all of these things down.
You are welcome, Sloan.
We're going to go ahead and we're going to start with a little bit of a raffle that we have going on. All of our attendees that are starting to pile in, we have this QR code here that you can go ahead and scan. Today, we're going to be picking 2 winners at the end of our webinar. Actually, Tim is going to help me pick a couple of winners. I'm going to give him some of our numbers and he can go ahead and pick those ones at random. One of our raffle prizes will be a $500 credit towards your surrogacy journey, and the other one will be a $1,000 credit towards your surrogacy program. We also have another promotion going on. It's going to be our Independence Day promotion. That one is going on until July 4th. So you can go ahead and enter that one as well with our QR code, and then those winners can actually stack those prizes if they win both of those. So that will be kind of cool, and it'll just kind of help save while starting your journey. So I will give them a second as we go through our PowerPoint as well. This QR code will be in the bottom corner of our slides. So if you did not get a chance to scan it right at the beginning, you will have a chance as we go throughout the PowerPoint. So we can do that. We've also got another one here in for consultation. So if you are a new intended parent joining us and you'd like to hear more about ACRC Global, whether it's for surrogacy or our gametes donation department, you can go ahead and schedule our consultation with our company and we can answer any questions and get you started on your journey. So we have that available for you as well. Perfect. Tim, I'm going to let you do a little bit of an intro on yourself as well as an attorney, and we'll kind of take it from there.
Thank you, Sloan. My name is Tim Schlesinger. I am a surrogacy lawyer. I am physically located in St. Louis, which is right in the middle of the country, but my firm and I handle surrogacies all over the Midwest. We handle surrogacies in states that all are in the middle of the country, and that's what we do all day, every day. It's incredibly rewarding. I've been practicing law for a long time, 42 years. And for most of my career, I did things that were filled with a lot more stress and a lot more conflict. Now I'm both proud and happy to be able to say that I spend all my time just trying to help people have babies, trying to help them navigate the legal journey involved in having babies through surrogacy. I, uh, I'm heavily involved in various groups in the surrogacy world. Um, I'm the co-chair of a committee right now that's drafting model legislation that relates to assisted reproduction. And I devote all of my professional time to this field. And Sloan, I'll just ask you, that's enough about me.
That's perfect.
Um,
Perfect. We're going to go ahead and start with a couple of questions that we have for you. It'll be kind of like a Q&A. So we'll ask a couple of questions and get your that professional opinion from you.
okay.
The first one we're going to go for is, can you give us an overview of surrogacy laws in the states that your firm covers?
Yes, I can. I can and I can't, but I will do
I
my
know it's
best.
a very broad
That's right.
kind of
And the reason,
question.
and of course, the reason I say it that way is because my firm, it practices in 8 different states, and the process is different in every state. Let me give you just a little bit of background, give everyone just a little bit of background before we give the overview so that people understand sort of the overriding context of what I'm saying. The purpose of our conversation today is to help all of you become comfortable with and understand the benefits of finding gestational surrogates in the Midwest. And I think I can help you do that. As I said, I've been an attorney for 42 years. When I began, there was no surrogacy law. And I started getting involved in this field about 20 years ago. And 4 years ago, I started this firm that does nothing but surrogacy and assisted reproduction. And the reason I'm going through this is to explain that we've helped hundreds and maybe thousands, to be honest, I can't keep track anymore, but at least many hundreds of families have children through surrogacy. And in the United States, surrogacy is a matter of state law. The state law that applies is the law where the surrogate is going to give birth. And every state has a different process, and every state has different rules. So for you who are in the beginning stages of going through this process, what's the most important question for you? To me, the most important question for you is there ever going to be a problem getting parentage in any one of these states? And the simple answer, and this is what I want to emphasize. The simple answer is no. There is never going to be a problem getting parentage for you in any of the states in which we practice. So long as you know the rules in advance and you follow the rules, there will never be a problem getting parentage. So what do I mean by the rules? In some states, for example, require that there is a medical need for surrogacy. Some states do not. Other states require that if there are two intended parents in a case, that those intended parents have to be married. Other states don't have that requirement. Some states require, for example, that every party be more than 21 years old. For example, I had this happen in one case. If the surrogate is married, the surrogate spouse has to be 21 years old. So that's a requirement in some states. That's not a requirement in other states. So that's what I mean by knowing the rules in advance. And your agency can always, if there's ever a question, of course, your agency can always ask me, what are the rules in this state? What do we need to know in advance before we match someone with a surrogate in this state? Um, and so the bottom line is we've helped hundreds and maybe thousands of families in the Midwest have babies through surrogacy, and we have successfully obtained parentage for our clients in every single case. We have never failed to do that. That's the bottom line. And so the 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 number one point that I want to get across to everyone on this call is that surrogacy is legal and available and it works in the Midwest. Certainly, in states outside of California, everybody thinks about California, but there are 51 jurisdictions here in the United States, and in 49 of those 51 jurisdictions, surrogacy works very well. So, um, so the question in front of me is, can I give you an overview of surrogacy laws in the states that my firm covers? Um, Surrogacy we're in 8 states. In 7 out of our 8 states, surrogacy is basically a two-stage process. And in the first stage, an agreement has to be drafted. And the purpose of that agreement is to comprehensively set forth the the rights and the obligations for the intended parents and the rights and the obligations for the surrogate and the surrogate spouse if the surrogate is married. That's the purpose of the agreement. And the first stage of the legal portion of the surrogacy journey is to get that agreement done, to get it signed, and then to issue legal clearance to the fertility clinic so that the clinic can begin its work in preparation for the embryo transfer. So in those states where it's a two-stage process, in the in the second stage happens if the surrogate gets pregnant. And if the surrogate gets pregnant in every single state, then there is a process by which you either work with the state or you work with the court to obtain parentage for the intended parents. Um, there's one state where for domestic intended parents, you actually don't need to go to the courts. And that's Illinois. In all of the other states, you need to go to the courts. And the process is different in every single state. In 7 out of the 8 states, there we get a pre-birth order of parentage. In some states, we get a post-birth order in addition to a pre-birth order. In other states, we just get a post-birth order. But the process that's involved is filing. What we do is we draft documents that everyone has to sign. Those documents are filed with the court, and then the court will enter a judgment that says the intended parents are the parents of the child, and the surrogate is not a parent of the child. And as a result of that judgment, then the state will issue a birth certificate when the child is born that says that lists only the parents as the parents of the child, and the surrogate is not listed as a parent on the birth certificate. So that's essentially how it works in all of the states I'm in. There's one state that's different, and that state is Oklahoma. And in Oklahoma, the process is all front loaded in the beginning. So in Oklahoma, um, we not only sign the agreement before there's an embryo transfer, we also get an order from the court before there's an embryo transfer saying that the intended parents are the parents. So Oklahoma's process is different than the rest of them, but it's still a process that works. Um, I know there's a lot more questions. I could go. I could
No, you're
spend
good. I
hours
know it.
talking about
This
this
is
one, but let's
there's
let's
very
stop talking about
broad.
this one and we'll go on to the next question.
Perfect. We can definitely do that. Like you said, it is a very broad question, and every state is a little bit different. And even with those laws that are constantly evolving and changing, the main gist is, that it does work in every state, right? There are different procedures and protocols, but those are things that can be accomplished, and you're
Correct.
able to do those. So thank you. We
Correct.
appreciate that. We can move on to the next one, which is actually about the pre-birth order. So in which of these states can intended parents obtain a pre-birth order, and what is that process typically like? So I know you kind of touched on that, but go ahead.
Okay, so in 7 out of my 8 states, you obtain a pre-birth order. Um, and it's I can list them. You don't, obviously when you're matching in a given state, you'll ask about this specific state. But in Illinois, Wisconsin, Tennessee, Oklahoma, Arkansas, Kentucky, Texas, and I think I'm missing one. Um, I may be missing one of my states. In all those states, you get a pre-birth order. Um, and um, the process involves going to court and filing documents with the court so that the court will enter a judgment. In some of those states, a hearing is required. In other states, a hearing is not required. And I know that there may be a question later about appearing in person. There are no states in which I practice, in which my firm practices, where you have to appear in person. There are several states, for example, Wisconsin, Tennessee, um, Oklahoma, where there are hearings, but in none of those states is the intended parent required to appear in person. All of these places recognize that intended parents are coming from all over the world. And so intended parents are not required to appear in person. In some of the states, we do have hearings where the intended parents testify by Zoom, by video.
Awesome. That's very helpful. I know some of our intended parents have concerns about that and just the timing and things like that. So thank you for clarifying that. That's great. Are there states where a post-birth or post-birth parentage order is required instead? And how does that differ from getting a pre-birth order? And then regards to the general timeline.
Okay, so that's actually an easier question to answer because it's narrow, because it's pretty narrow. So
Mhm.
in Missouri, for example, in my home state, we get a post-birth order. Missouri is a great state for surrogacy, and I'll explain why later. But we do not get a pre-birth order in Missouri. We get everything filed and everything is ready to go. Everything is filed with the court and ready to go before the baby is born. Then, when the baby is born, we send a notary to the hospital the next day to have a judgment signed. We file that judgment with the court, and then within a few days, let's say within 5 to 7 days of the birth of the baby, then we have a judgment that says the parents are the parents of the child. And then we send that judgment to the Bureau of Vital Records, and Vital Records issues a birth certificate that lists only the parent or only the parents um, as the parents of the child. That's how that works in Missouri. In Wisconsin, for example, you get a pre-birth order and you have to get a post-birth order. And again, that post-birth order is what goes to vital records so that only the parents are listed on the birth certificate. In Tennessee, it depends in Tennessee, if one of the parents is not genetically related to the child, then you have to get both a pre-birth and a post-birth order. And in Tennessee, what happens is you first obtain the pre-birth order, and then after the child is born, you obtain a post-birth order. It's actually an adoption. You obtain a post-birth decree of adoption which names the non-genetic parent as the parent of the child. And then once you get that decree of adoption from the court, you send that to Vital Records. And once again, Vital Records then issues a birth certificate that lists only the parents as the parents of the child. And the timeline's different in every state. In Missouri, we'll have a judgment within, let's say, 7 days of the baby being born. And there's a document, and in case you're concerned about what happens in those 7 days between the time the baby is born and the time the judgment is entered, there's a document that the surrogate signs and that the parents sign that gives the parents all of the authority they need to take care of their child for that brief period of time before there's a judgment. And then when the judgment is entered, then the parents are the legal parents. Um, the In Wisconsin, uh, there's a hearing required after the baby is born, and that usually takes place a couple weeks after the baby is born, and then a birth certificate's entered. And in Tennessee, there are two different ways to do it, but assume that the final decree of adoption will be entered, let's maybe 6 weeks after the baby is born. But in Tennessee, even though you can't get the final decree of adoption until 6 weeks after the baby's born, there's already an order of the court entered that says that the genetic parent is the legal parent of the child, and the other parent is a guardian and custodian of the child. So everyone already has all of the legal protections they need to take care of the child. So, as we keep emphasizing, the process is different in every state, but ultimately the process works in every state for the parents.
Understood. I know that some of our intended parents it is a bit nerve-wracking, right, to not be able to do it prior sometimes. So I know that that's a big question for some of our intended parents who have surrogates in states that a post-birth order is required. So I appreciate you breaking it down and just kind of letting us know that even if that order is not, the judgment is 6 weeks out or more or less, that there are procedures in place and documents that allow them the full rights and responsibilities to their child in between those times. So thank you. Our next one is going to be, oh, well, yep.
Yeah,
The
this is a
parent,
good question to answer.
yep,
This is a very good
yep.
question.
So
So,
they are just kind of your perspective on if this concern is valid, although it happens, the risk and things like that.
yeah, it doesn't happen. Here's the thing, it doesn't happen. So, you know, I know that some intended parents worry that a surrogate could change their mind and could somehow try to take the baby. That does not happen. It doesn't happen. Um, it's um, I've never even had a hint of it. I've been involved in probably 1,000 pregnancies just myself, not even talking about my partners. I've never even had a hint of a surrogate wanting to care for it for the child. It doesn't have it simply never happens. It's not a realistic concern. It's just not something that you need to be worried about. Doesn't matter whether it's a state with a post-birth order or not. You have valid enforceable agreements, and you have courts that are going to enforce those agreements. And what's frankly more important than that, the surrogate does not want to take this baby. It just simply doesn't work like that.
Right. And if I may, with our agency, before we even get to a stage in which we're working on legal contracts or birth orders, we do have psychological screening and conversations with our surrogates so that they are, aware, on the same page, their expectations are all met. That, like you said, never happened in my experience either. So it's always something that is something that the intended parents may question, but we have full reassurance that that is not something that we have ever experienced or have major concerns about. We do touch on it, just so that everyone is on the same page, but yes, I agree, not necessarily something that is happening. This is a common question from our IPs. Out of the states that you cover, which would you describe as the most surrogacy friendly?
So I'm going to answer this question in a way that is going to be surprising.
Okay.
I work in one state in which you cannot get a pre-birth order. That's Missouri. You know which state is the most surrogacy friendly? Missouri. And here
Very
is why.
interesting.
Here is why. In all of the other states, there are statutes that regulate surrogacy, and there are requirements. For example, you might have to have the doctor prove that you have a medical need, or you might have to have a hearing, or you might have to have there might be other requirements on who's allowed to be a surrogate. That other states have requirements of, where you have to submit statements from the mental health providers for evaluation. In Missouri, what has happened, because we do not have a statute, but I have a friendly court, and for example, in my case, I have a judge that's assigned to me to issue my judgments in all of my cases.
Hmm.
So he's a judge I've known for 35 years, and the uh, point is that every judgment I give to him, he just says to me, "Where do I sign?" Um, so Missouri is very surrogacy friendly because even though you cannot get a judgment till after the baby is born, there are no requirements. So everyone is available. Surrogacy is available to everyone in Missouri without any obstacles in advance.
Perfect. Good to know. Missouri. Okay. We can go ahead and move on to our next question. So as you kind of said, Missouri is going to be your most surrogacy friendly state. In comparison, a lot of our intended parents are most drawn to California, due to its reputation as a surrogacy friendly state. Do you see more legal risks or complications in any of the states that you work with in compared to that California laws?
Well, I guess I mean it's not legal risks. There aren't any legal risks, but there are complications.
Okay.
So let's separate those two things. In all of the states in which I work, there really aren't risks as long as you don't do something you're not supposed to do. For example, don't don't match a surrogate in Oklahoma that doesn't have a with intended parents that don't have a medical need. That would be a there's no risk as long as you don't do something like that. Or don't match here's another example, don't match intended parents with a surrogate in Oklahoma who's married to someone who's only 19. Don't do that. That's not going to work. But as long as you know the rules in advance, there really aren't any risks. So the question is, are there complications compared to California? Well, first I have to say, I don't know exactly how the process, I have some knowledge of how the process works in California, but I don't know exactly how it works. So I'm not exactly comparing apples to apples, but um, what I can say is that there are some states where, um, depending on depending on the situation for the intended parents, it might be a little more complicated than it is in California. For example, in Tennessee, let's say you have a same-sex couple. So if you have a same-sex male couple, obviously then one of those two parents is not going to be genetically related. Now, they're still going to be the parents, but that requires, since one of the parents is not genetically related, that means you have to get a pre-birth order and then you have to get the adoption after the baby is born. And it's a simple adoption process. It's not complicated, but it's more complicated than California. Okay. You have to have a Zoom hearing before the baby's born. You have to have a Zoom hearing after the baby's born. You still get to where you need to be and you get everything you need, but is it more complicated than California? Yeah, maybe it is.
Well, and
Um,
maybe even complications is not the correct word, right? Even just more steps or
there's
more
more steps. That's right.
different
That's right.
procedures, things like that.
Yes, thank you, Sloan. That's accurate. It's really not more complications. It's just in some of the states there are more steps than there are in California. For example, in Wisconsin, as I said, you have to have a you get a pre-birth order and you get a post-birth order. Now, the pre-birth order is issued by the court without a hearing. There's a post-birth order that's issued by the court after a Zoom hearing. Um, so that's more steps than California, but it's still a smooth process that works every time. In some states, frankly, it's simpler than California. I mean, in Illinois and in Missouri. So I said Illinois is the most surrogacy friendly. I mean, I said Missouri is the most surrogacy friendly state. I might get arguments from my friends in Illinois, um, because Illinois is also very, very surrogacy friendly. For domestic intended parents, you don't even need to go to court in Illinois. Now it depends. We advise same-sex couples to go to court in Illinois, even though you don't have to. Just because in case you move to another state where the law might be different, that gives you protection. But Illinois' process is very, very simple for getting parentage. So Illinois is very friendly. Illinois I mean, frankly, easier than California. Missouri is easier than California. The other states, Oklahoma has more steps. Oklahoma and Tennessee have more steps. Maybe Wisconsin has more steps, but none of them have more legal risks, and they don't really have complications. Does that answer the question?
It definitely does. Thank you. Yes, that's
Okay.
perfect. So can international intended parents complete the legal process entirely from abroad? I know you kind of touched on that one. Sometimes it's more not necessarily necessary, but maybe you can kind of say whether it's
So here's the thing about that. And I have so I'm going to answer the question. The answer is no. I mean the answer is I'm sorry. The answer I was using it in the negative. The answer is yes.
okay.
The answer is yes. International intended parents can complete the legal process entirely from abroad. Absolutely. In every state in which I practice, the intended parents can do this without ever stepping foot in the United States. That's the answer to the question. However, I think it's bad for surrogacy,
Okay.
um, in general, um, to have intended parents not come to the U.S. to be there for the baby. I think that creates potential political problems if we're worried, if we are worried about what legislation might happen in the future. That's the kind of thing where when the parents don't come for their children, people who are against surrogacy um, will use that to paint a picture of surrogacy that is inaccurate or misleading. And so, although you can accomplish this in all of the states in which I practice without ever appearing in the United States, my recommendation is that everyone appear. I think that's what's good for all of us in the field. And that's what will be good for future intended parents who want to be able to avail themselves of surrogacy.
Right. Yep. And we always recommend as well, as the agency, although you can, like you said, complete the entire legal process entirely from abroad, which happens with the contracts earlier on and then the birth orders a little bit later on. It is always recommended from our end as well to appear to come and be present as available to pick up the baby. We know that birth is a little bit unpredictable, so that timeline can vary, and it is sometimes tougher to get there right on time. But definitely come to the hospital when the baby is being born and things like that is always our general recommendation as well. So appreciate that. And you kind of touched on this one about appearing in court. I know every state is a little bit different, but are intended parents ever required to appear in court in any of these states? Which ones to establish parentage?
So Sloan, do we have any surrogates on this call?
Most of our participants, I believe, are all of our attendees are intended
Intended parents?
parents.
Okay. So there's one state, for example, there's one state in which surrogates actually have to appear in person, in a court hearing in person. Intended parents do not. That's Oklahoma. Um, um, Intended parents are only required to appear in court in some states by Zoom. Currently, I don't currently have any states in which intended parents are required to appear in person. This all changed during COVID. Courts, we didn't have Zoom hearings before COVID, and now courts understand that Zoom hearings are efficient and can be used well. So all these types of hearings are done by Zoom, except in Oklahoma, but the intended parents don't have to appear in Oklahoma.
Okay, awesome. Um, and again, I know that you've kind of touched on the LGBTQ plus couples. We assist many of those as well. So how do the surrogacy laws in your states that you cover address their specific needs? Or
In
if it
all of
varies?
the states, in all of the states in which, excuse me, in all the states in which I practice, um, the process works exactly the same for LGBTQ plus couples as it does for hetero couples. In some states, it works a little bit differently for single parents. Doesn't work, and it doesn't work. It's not a problem for single parents, but the process in some of the states is a little bit different. For example, in Illinois, for a single father, I have to go to court to get a judgment so that we can correct the birth certificate after the baby's born. Because in Illinois, the birth certificate actually says the words gestational surrogate in the box where it says parent. And in many of the countries that Sloan, that ACRC, and that all of us deal with, in many of the countries, they can't have that on a birth certificate. So we go to court to have that removed after the baby is born. It's a simple process, very simple process. In Tennessee, for example, um, same-sex couples have to go through the adoption process because by by nature, one of them is not going to be genetically related to the child. And although it's no different for a hetero couple than it is for a same-sex couple, we know that for every same-sex couple, one of them will not be a genetic parent. So they have to go to court. So they have to go to court to get an adoption. For a single parent in Tennessee, actually for a single father in Tennessee, there's an extra court order that we get. It's not a big deal. It's just a little extra step in the process, but it all happens at the same time. The bottom line is really the law works the same for single parents and LGBTQ as it does for anyone else, but sometimes there are little tweaks in the process that we have to go through.
Perfect. Awesome. Yep. Another one of those things where maybe not more complicated or anything like that, but it's possible there may be an extra step in there
Correct.
or
That's
just a different
that's
one. So
exactly right. Exactly right.
awesome. Okay, great. We can move on. Surrogacy law is constantly evolving and changing. Are there any legal or legislative trends that you're watching in the Midwest right now that intended parents should be aware of for 2025 and beyond?
Um, I don't think so again, this is the kind of thing I could talk for hours about. So the short answer is not really.
Okay.
I'm just going to say a couple things about this. In the past 10 to 15 years, we've seen numerous states pass surrogacy laws, making surrogacy legal and establishing a specific framework for how you accomplish surrogacy and how you get parentage after a surrogacy. There hasn't been a state for 25 years that has passed a law that says surrogacy is not legal or surrogacy is unenforceable. So if there's a trend, the trend is that surrogacy is legal all over the place. There are 50, not counting the islands in the Pacific, there are 51 jurisdictions here in the mainland US plus Alaska and Hawaii. And in 49 of those 51 jurisdictions, surrogacy is legal and available. I suspect eventually, I can't speak for Louisiana, probably eventually in Nebraska it will be legal. Louisiana is just different than every place else. It has a different legal framework. Um, but really the answer is the trends regarding surrogacy are good. However, we do have to be aware of our political climate and 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 we have to be aware that if people in the surrogacy field, if there are bad actors in the surrogacy field that make us as a field look bad, that could create problems for people in the future.
Great.
It's the easiest way for me to answer that.
Makes sense. Definitely. Okay. What key legal protections are typically built into surrogacy agreements for both the intended parents and our surrogates?
Wow, what key legal protections? Okay, so the fundamental principle of every surrogacy agreement is that if a child is born from any of the embryo transfers that are contemplated in that agreement, that child is the child of the intended parents, no matter what anyone does. It doesn't matter if the intended parents change their mind. It doesn't matter if the surrogate changes her mind. It doesn't matter if the intended parents breach the agreement. It doesn't matter if, for example, this wouldn't happen, but if somehow the surrogate didn't get any of the money that she was entitled to under the terms of the agreement, it still doesn't matter. That child is still the child of the intended parents. The intended parents have 100% of the parenting rights and 100% of the parenting obligations. The surrogate has no parenting rights and no parenting obligations. That's the fundamental protection that's built in. Obviously, the protections for the surrogate are that, the surrogate, you can't force a surrogate to undergo a medical procedure. Um, surrogates can terminate an agreement at any time so long as they're not pregnant. That's a that's a protection for the surrogate. That's also a protection for the intended parents. The intended parents can terminate an agreement at any time so long as the surrogate is not pregnant. Um, every agreement, every agency agreement, of course, has an escrow agency involved so that the escrow aid, that's a protection for everyone. That protects the intended parents and protects the surrogates so that there are not disputes over what money is supposed to be paid and when. Um, intended parents are protected because we have provisions in each of these agreements that if the surrogate materially breaches the agreement, then the parents can sue for damages for that material breach. So those are the, these agreements are, my agreements are 37 or 38 pages single spaced. So I can't go through all of the protections that are in these
Yep,
agreements.
that's
But those are really the big ones. Those are the main things.
definitely. And that's important too, just to kind of touch on that. All of our surrogates and intended parents each have their own legal attorneys, so there is no conflict of interest, so that they are protected on that end, as well as, having separate meetings. I know, Tim, you meet with all of the, surrogates or intended parents, whoever your client is at that time, to discuss all of those things, make sure that they're comfortable. You give them all
Yes.
of their, rights and things like that, so that everyone's on the same page. And not only legally are they protected, but they feel that from the contract as well. So that is important for us too. Is there any essential advice that you would like to give to our intended parents when choosing their surrogates?
I think the most important advice I could give is that the most important thing is that you be comfortable with your surrogate. Make sure that you're, and I'm not speaking about ACRC because they're very knowledgeable, but still, it's hard to keep track. Even ACRC, they're doing surrogacy in 49, probably 49 different jurisdictions. It's hard to keep track. So I have two pieces of advice. Once you get when you're thinking about getting matched, or when you do get matched with someone from a specific state, make sure that that match doesn't violate any of the rules of that specific state. That's number one. But number two, once you figured that out, if you know that your match doesn't violate one of those specific rules from a specific state, then my number one piece of advice is it's more important. The different processes from the different states are less important than finding a surrogate that works for you, finding a surrogate that you're comfortable with. That to me is more. Since my firm practices in 8 different states, and I've experienced all these different processes, I can tell you from a lot of experience that what really matters is having a surrogate that you trust and that you're comfortable with. Because all of the legal processes, we know how to work through all of the legal processes. That's less important than having a surrogate that you trust. That's my essential advice.
Amazing. Thank you so much, Tim, for answering all of these questions. We really appreciate it. We're going to go ahead and, Tim, I'm going to send you a message here with all of our entries and our numbers. I'm going to go ahead and have you pick two. So our two prizes for today are going to be a $500 credit towards your surrogacy journey and $1,000 credit towards your surrogacy journey. So, Tim, at
Oh,
random, we kind of make,
wait, the numbers just went away.
oh, they went away. Let me,
They were there for a minute.
you might be able to click down on my chat. Let me,
Oh, I got them.
oh, perfect.
Okay, that's better. Oh, and they weren't all showing before. Now I've got them all. Okay. All right. So the first number I'm going to pick is 607857.
Perfect. One more. Oops,
The
sorry.
next number is 754769.
Perfect. Amazing. Thank you so much, Tim. Congratulations to our intended parent that won. We're going to go ahead and open up our chat as well to see if anybody has any questions. Any of our attendees have any questions for Tim or myself. So if there are any, please go ahead and drop it in our chat. We're happy to answer any questions or anything like that that we can go ahead and do while our attendees are still on. Let me see. Oop, she's moving around. Perfect. I don't have any questions on there. But again, you are welcome to reach out to us directly. I can have Eva go ahead and put back up our QR code for any consultations if there are any questions that maybe you want to reach out to us with afterwards, and we can do it that way. But again, thank you everyone for joining us. Tim, thank you for your knowledge and sharing that with us. We really appreciate that. And we hope everyone has a wonderful rest of the day. And again, reach out if anything else is needed.
Thank you, Sloan, and good luck to everyone. I hope everybody has a successful journey.